Now, the Constitutional Court has declared critical parts of the law governing surveillance in South Africa unconstitutional and has made provisions for immediate recourse. The Regulation of Interception of Communications Act is a South African law that regulates the interception of communications. The law came into effect on 22nd January 2003 when it was published in the Government Gazette of South Africa. Joining me now is Cherese Thakur, an Advocacy Coordinator for Amabhungane, to unpack the ruling. Cherese, a very good morning. In layman's terms, what is RICA?
So RICA is the legislation that governs surveillance of communications in South Africa. So it's basically the enabling statute. We all think of RICA as the hoops we need to jump through when we want to register a new cell phone contract, for instance. But what that enables when we provide our personal information is that should there be a need to monitor communications, like, for instance, for the interests of state security, or where, for instance, there's an investigation of a crime, RICA is the statute that will enable that.
Now, one Sam Sol took them to court, took the matter to court. What were the circumstances surrounding that?
So Sam Sols is our managing partner here at the Amabhungane Center for Investigative Journalism. And his communications were being intercepted. In other words, his phone was being tapped. And he didn't know about it. And this is one of the deficiencies that we identified in RICA. And the only way that he was able to find out was that a conversation that he had, a personal conversation between him and Billy Downer, an advocate who was involved in the prosecution of Jacob Zuma, ended up in court papers that Sam was able to get his hands on. And of course, I think anyone would be very surprised to see their personal communications ending up in court papers in that way. And that's how he realized that he was being bugged, his communications were being bugged. And this really prompted this court case in the High Court that's now being confirmed by the Constitutional Court. So
obviously, bugging is real. It's not just stuff that we see on television. Is it because of Sam's role as an investigative journalist?
Probably so. Can't say for sure, but I mean, given the nature of what was being, what ended up in the court papers, it really seems that was the case. And we've seen in the past week or so revelations about how state security structures were used to monitor journalists and civil society members, people who have been speaking out against misuse of public power. So that is a very, very real concern. And that's why this judgment comes at precisely the right time, so that we can guard against any further infringements.
Now, I'd just like to draw you to something that I picked up on your website earlier. And I quote, "Our investigative stories, exposés on institutional independence being undermined, corruption, corporate malfeasance, and state capture have contributed to political and corporate changes that included the resignation of South Africa's president in February 2018. Could this have been a factor? One is likely to draw some form of relationship between the two incidents.
Indeed, it could. We, as I said, we can't say for sure, but I mean, there's a huge suspicion that was the case. And the main issue was that there was no way for Sam to know that he was being watched and his communications were being intercepted. And one of the developments and the findings of the Constitutional Court was that there needs to be something called post-surveillance notification. So if the authorization is granted for your communications to be intercepted, once that period of surveillance ends, you are required to be notified of that fact. And that will enable you to protect your rights. So if you believe that surveillance was unlawful, you can go to court and challenge that. But if you never knew about it to begin with, you would not have that option. So that's why this judgment is so important.
Now, does a state have to go to a judge or go to any other authority to seek permission for surveillance?
Yes, so that is the procedure that's built into RICA. There's a designated judge, so that is a retired judge. But unfortunately, RICA provided that it was that the designated judge is appointed by the minister, and the problem with that is that there was insufficient independence for the designated judge, particularly as the period of renewal, so that the time on which the judge would serve in that position could be renewed. So those are issues with independence that were definitely present, and the Constitutional Court found that was constitutionally untenable. There's also the issue that, of course, you will never be told in advance that you're going to be the subject of surveillance. So when they go to the designated judge, that is ex parte proceedings. In other words, there's no defend on your side, even though you're not present, but there's no one to take into account your interests. It becomes very one-sided. And the Constitutional Court found that this was also constitutionally problematic. And that was one of the orders that were made. So Parliament, when they are going through the process of curing all the defects in RICA, are going to have to address that issue as well.
Now let's talk about possible abuse of the ability to call it spy on our conversations and telephones. Now, RICA is supposed to help prevent criminals from using cell phones for illegal activities. Now, I'd like to think that none of what Sam Sol was doing was illegal or criminal in nature.
No, it certainly wasn't. And that goes to show that this process was being abused. And one of the incidents that were mentioned in the Constitutional Court judge in respect of two journalists was that when they went to the designated judge in order to approve or get authorization for surveillance against these two journalists, they were blatant lies were said to the judge. So there was incorrect and false information. And the judge obviously cannot be impartial and give a correct decision on that basis. So that's the problem with the ex parte procedure. It just had none of the safeguards that are so necessary.
Now that the Interception of Communications Act has been deemed unlawful, what happens next?
So Parliament has 3 years within which to cure the defects in RICA. This is quite a lot of time. And through this litigation, our lawmakers should have been alive to this issue of the unconstitutionality or the problems with RICA. So we are hoping that they will not take the full 3 years, that they will do so as quick as possible, get on the job of fixing this legislation. Luckily, in the meantime, there are some provisions or protections that have been provided for in an interim order by the Constitutional Court, and those relate to, firstly, the post-surveillance notification. So even though Parliament will be curing RICA in time, the post-surveillance notification requirement will apply immediately, as well as additional protections for the communications between a lawyer and their client, as well as journalists and their confidential sources. And this was a very important finding by the Constitutional Court, that RICA was unconstitutional in that respect. And so these protections are effective immediately. There's another aspect of the judgment as well, which concerns bulk surveillance, which is the monitoring of all communications that go out of the country. You can use keywords, for instance, or you can track a person's email. And this was just a very widespread form of surveillance. And that was declared unlawful in the sense that there's no empowering statute that enables the government to do that. So that practice must also end immediately. And that's a great result for journalists and also just all South Africans as well.
Cherese, lovely speaking to you. Advocacy Coordinator for Amabhungane, Cherese Thakur.